If you had four guys just standing outside looking at him, what will you have discovered? Nothing. Because you will know that he got an USB, you will know that he inserted it into computer, he was sending out some information. Now see, further little more investigation into this whole thing revealed that the USB he was carrying has scanned photo images of troop movements in the border. For example, how many trucks are going every day, how many this is how, in the army, this is how, they calculate the troop strength in any location. They'll have one guy who will be just monitoring how many trucks are going. Per truck, this many people. Then they calculate the number of troops. Now, this is a very critical thing, at time of war. So, what happens is, when you start looking at this information was coming to him from different sources. He was in his house, scanning these documents and putting it onto USB, and he was sending out. Now, this is a very ingenious method. Why? Because when you scan an image into USB, it is image file. It is a JPEG or a BMP. You can't scan text inside that. Now the sniffers can only scan text inside. So he evaded effectively the entire security system what is there in place. He was just caught by accident. So why I am telling you this is, now looking at the other side of the challenging issue, now can you know who he is without knowing what he is doing? You cannot. So, see, it is more like I am putting up certain challenges, certain issues on the field, so that actually you can, brainstorm and you can come up with your own thinking on these things. The second is a small case study where funders from outside the country, they are actually, using email IDs and sending, using Gmail, Yahoo, to people here. You know what they will write? They will write just this line. They will say, we are sending 2 patties to Delhi by FedEx. One number they will give. Patties means money. FedEx is parcel service. So you have to go and start tracking at that. So until you don't intercept this information, you don't know what is actually going there, and you cannot investigate into what is actually there inside that parcel. Now see, what happens is, these masterminds are not operating at same locations, but they are operating at different locations. Now see, what happens when you go to an ISP and you say that this is a Dropbox, there is an email ID, and this email ID is used by 2 parties. ISPs give you IPs from wherever they are accessing this, but you will never be able to identify which of the 2 persons is communicating what, because both are posting into the same email ID. Both are operating from different IPs. They are not same physical location. So the whole process of understanding and collating this information and making a sensible information out of this becomes extremely difficult until some method is found out. And most of these terrorists also use their own encryption. It is not that they use standard encryption schemes. I have personally analyzed and reverse engineered one particular tool, which was like, you type a message and you double click on that message. It will immediately disappear and it will become full of junk. Only the other side, that person with the same password can open it. Now this program is not something which is available on internet, but they have themselves developed it. So we are actually talking about technically capable guys inside these terrorist groups. Now see, coming to the other aspect of this whole thing is the cyber defense. I'll just take another 5 minutes. The other aspect of this is the cyber defense. Now see, we have got government where everything is running on e-governance. So there are portals, web portals which are operating out of NICs and other places, which is for land registration. You can do a lot of things today in portals. Now what happens is, in US there is a separate agency which is called the National Infrastructure Protection Center, NIPC, which actually technically was operating under FBI, but now it is operating under the Department of Homeland Security. Now this agency's pure job is to ensure all the critical infrastructures are protected. Now I will just give you one case. In 2003, after the September 11 attack in 2001, September 3, suddenly there was in New York power outages everywhere in New York, and lifts were hanging out for like 40 hours. They could not get the people out because it was on the 115th floor, 110th floor in different buildings. Entire power shutdown was there in US. Now when they started investigating it, what they found out was one of the private companies which was controlling these power grids. Now in US it's not like in India, you don't have just wires and no computers. Everything is controlled by the computers and control systems. So there is a famous system called SCADA, SCADA. So which controls all these, energy related, things. So what they have done, the cyber terrorists, that's what they claim, they have actually taken off one or two computers inside these power grids, and they effectively shut down the power supply of a city for 40 hours. Even with a national infrastructure protection center which is full-time operating in place. See, what happens is you might be able to neutralize 90 different modules, but there will be out there 10 modules which out of which one will be finally successful. Unfortunately, what happens is we always look at the failure rates. We never look at the number of success rates because we don't know, that how many have been neutralized. Now, see, also there are certain times when communications flow on emails. Without naming, a particular this thing. See, the second point. I actually came across once a communication of a top individual in the state, in the government, whose password was just password. The email system's password was just password. So there was, of course, there was an incident. I was, involved in the post-mortem of this whole incident. When I was looking into it, the password was just password. People fixed the system, they supplied the system, they ensured everything is safe, but finally they didn't change the default password. So finally what happens is, if a terrorist is able to get hold of this, he is going to start looking at every communication. Let us say one of the top VIPs is moving in this particular locality, and on the briefing sheet, there is a small document file, on which it says at 3 o'clock he is going to be at this location. When the terrorists know where to attack, at 3 o'clock means 1 hour before, he will be monitoring that route, and at one particular point there will be an ambush. So this is what happens. So it's one aspect of it is tracking the terrorists. The other aspect of it is protecting the government critical systems, be it emailing systems or the web portals, from terrorists attacking it. So I think this is the other portion of it. Now see, prevention is a key. It's not like always enough that we do a post-mortem of every single attack and then we start working on it, doing a post-mortem analysis. We have to stop things from happening. So most of these systems can be looked upon by experts, and they can fix the loopholes in these systems. Now there is one more point I want to stress here is, I have personally found this. Most of the critical information in government computers, in private organizations, in even top MNCs in India, I have seen that most of the important information will be there on the laptop. And this laptop, what happens is, see, we always get a laptop even in corporate. I worked in a corporate, so I know this. So we have a standard image set. See, the laptop all will have the same type of configurations. So when we actually go and plug it in to any network, we assume that our company has given it quite securely to us. But we are not thinking of certain things. For example, see, I land up in, say, Uttaranchal or Jharkhand, and I have gone for a government business there. I am robbed at gunpoint, and my laptop is taken from me in hand. Can that guy get hold of the data what I am carrying? Yes. Because most of us, we don't do a encryption of our laptop data. So it's very important that we do an encryption of our laptop data. Every single computer, laptops in the government and in private sector, where important information is. Now I'll give you a second scenario. You are carrying the laptop, you have not been robbed, but what happens is they kidnap you. Now they kidnap you, and then they are promising that they will really torture you, if you don't give the password for the data. Will we give it or not? Yes. Because we can't bear it. So what happens is, there is something called the steno encryption. See, what it means is, we always standardly follow some of these procedures, in the defense forces also. See, what happens is, one information will be the actual information, one will be the false information, the deceptive information. So we modify this information a little bit, and with one password, the actual information will open, with another password, the deceptive information will open. So, so this is how, we ensure that the data is secure. Now, third thing is the anti-bugging technology. I'll give you a simple example of a case. A very important document file was taken off from a computer, a very important man's computer, a decision maker's computer. Now, nobody knows that this data leaked. So we have to have anti-bugging technologies in place, and we also have to have tracking technologies in place. See, if somebody steals this information and takes it out, it should be able to tell us back that I have been stolen. So that's the most important thing. So these technologies are there. There are enough challenges. I have put down a lot of challenges. Now I am not concluding anything on this. But these are important challenges before we can understand privacy. So I conclude my session with this. Thank you.
As the positive march of technology takes place, the negative march of technology outpaces the positive march. In other words, the criminals get cleverer and they use all subterfuges to steal the technology that is developed by the police and other law enforcement personnel in order to go a step ahead of the law enforcement agency. Now, what do you do under these circumstances? It was a very, very revealing presentation, and of course, he said every laptop should be encrypted, but then what happens if the laptop is stolen? Then you have to have tracking technology. These things, I wish we have a whole day seminar or even a couple of days seminar on this aspect itself. I mean, this is an appeal to Mr. Navi. If you all agree, we'll have because the subject today is these two bills which we are considering, the Information Technology Amendment Bill and the Personal Data Protection Bill. We have only heard the two experts speak out on those bills, and Mr. Prasanna on this the technological subterfuges those take place. However, I think since we are short of time, what I will do is I will just invite basic, just not more than 2 questions per lecturer today. If any urgent or very important questions are there, can I throw it open, please? Then first subject is Dr. Vijay Kumar's privacy rights protection and their limitations of the Indian Constitution. Any questions? First, two. Yes.
My question is, we work for an MNC company, and I'll take an example. So we work for a company, Australian-based company, and Australia, they have a privacy act and privacy rule, and if privacy breach happens in Bangalore for an employee working for a multinational company governed by Australian Privacy Act, and a breach happens in Bangalore, and assuming we have this bill passed and there is a privacy act that comes into play, would there be any conflict between these two countries' privacy act? That's one question. And second question, will there be any immunity for the employee in this country, saying that, yeah, I belong to this country, rule of the land holds good, and I cannot be prosecuted by Australian law?
I think when the world is moving towards this accountability issue, there are two different legislation working on the same protection of particular data. I think I don't see much of a conflict there. The second question is a little bit more complicated in the sense that as far as the jurisdiction is concerned, will Government of India hand over a citizen of India to the jurisdiction of another country and ask them to prosecute them and punish them under that particular law? It's a difficult question. No state is willing to do that. But I think in international law there is a circumventing of all these hurdles, and that is taking place in various forms. It's called as universal jurisdiction. So over a period of time, they may also tell the Government of India, forget about the applicable law, but you have an obligation to prosecute him and punish him. And what law you punish is immaterial. Whether it is Australian or Indian, it is immaterial. We are interested so long that this particular individual is punished. That is what we want. I think slowly things will move in that direction of giving universal jurisdiction. Otherwise, no state, however small it is willing to hand over its own citizens for being prosecuted outside in another state.
Thank you.
Can I just top up that question? Second question? Yeah, say if we have signed a declaration, whenever I enter into contact or accessing the information or receiving or processing anything of the information, I sign a declaration to that respective country telling him that I'll abide by the rules and regulations, whatever is governing the information in subject. Then does the scenario changes or still it holds good of your answer?
I think at least what can happen is if you violate the contract, they may take you off the job, that's all, for the time being. But whether you will be prosecuted here in terms of the violations that you have caused for the contract which you have entered into with an outside agency, one has to look into all the terms and conditions. I cannot give a straight jacket answer for all these things. But I have to look into the terms of the contract and the obligations undertaken by the state, which permits that type of contract to be executed here on the Indian soil. So it's a little bit complicated. Maybe if we have all the information before us, we can certainly guide you.
Thank you.
Yeah, okay.
Sir, you spoke about comments of a U.S. senator, U.S. vice president. I'd like to remind you of the comment of the second U.S. president and one of the founding fathers of that nation, Thomas Jefferson, who said, "Those who are willing to give up liberty for the sake of security are deserve neither." Okay, so. And I really appreciate the lucidity that you brought to the topic and your outlining of the safeguards that have to be reasonableness, proportionality, etc. That privacy itself is subjective, but this is also a point that I agree with.
Now moving on to the second subject of Mr. Sudhir, Personal Data Protection Act 2006, a critical analysis. Any questions on that, please? Would you please announce your name?
My name is Pranesh Prakash. I'm from the Center for Internet and Society. I have a few questions that actually over lunch I have been discussing with them, but I want to throw into the house as well. One of the points, one of the most crucial points in this discussion was the fact that information should be viewed as property. Now, while I understand his rationale for it and saying that we need better enforcement, etc., I believe that it betrays a lack of conceptual clarity, because some of the main fundamental features of property, one of them is the notion of excludability. Okay, that you can exclude others from having what you have at the same time. That is what is one of the fundamental features of property. The most fundamental, many would say. James Baldwin said something. Secondly, is the notion of alienability. Okay, now this is not as crucial as excludability, but alienability would basically mean that something that is mine, I can divorce my rights over that and give those rights to someone else. Now, I find it difficult to see information as property, given that property requires these two things in the minimum. Because property, I can have some information, at the same time someone else can also have that information. So it's not excludable information. And information, for instance, my name, I can't alienate my name, I can't give away my name to someone else. But that is also the kind of information that the personal data protection bill seeks to protect. Right? So I have a problem with that. Secondly, there's the issue of it being absolute, it being an absolute right. That is at odds with the constitutional dealing with of property. Thirdly, there's the issue of him wanting to deal with it as criminal law, because that would make enforcement easier. Now, I see criminal law as a special kind of law. Now, not every wrong is a wrong against the state. For instance, I can be defamed, but unless it's criminal defamation, then it doesn't come under criminal law. Something like nuisance, unless it's criminal nuisance, doesn't come under criminal law. So just because I'm harmed doesn't automatically make it a criminal subject. Now, I'm not precluding the possibility of this being a criminal subject. I'm just saying why it is a criminal subject and not a civil one. Okay, because the Act talks of damages. Okay, now why, and damages can be ascertained even in civil cases, torts, etc. right? And even some constitutional wrongs have been held to be torts and not criminal wrongs. So that justification for why it should be treated as criminal subject matter did not come out in that presentation. And the analogy of drafts and saving of drafts, as Mr. Prasanna pointed out, was a bad analogy. And thirdly, I want to commend him on the point he made about public domain. What is in public domain not being defined? That's a very important issue. But the problem with his analysis of section 2, the definition of processing, of data processing, is that he said even obtaining, that comes before that is also covered under processing. I urge him to read that sentence more clearly. Okay, that definition actually uses the word and. It does not use the word or. So obtaining, holding, recording, etc. Okay, those kinds of that activity and operation on that data, those two put together constitute data processing, and not just, it's not an or between those two things, it's an and. One of the there are a few other problems. Actually, I could go on, but actually I'll just ask one other question. Now, section 10 actually talks about, actually he made a point about that in his presentation, about without his knowledge or due diligence. Now it gives an option. So if a superior, so I believe that it should be just due diligence and lack of knowledge of someone junior to me committing some wrong with that data should not be a defense for me unless I have actually been responsible, unless I've actually acted with due diligence. I've actually tried to put in place certain processes whereby that doesn't happen. So that's my answer to the question.
Thank you.
Coming on to the excludability and the alienability, well, we all have softwares. We just take a license to it, but the creator of the software becomes the owner of it. He is still the owner, but we are in possession and we only have a license to use. The same analogy has to be used here also. One. Second one, criminal breach is for the recipient of that information as an organization, not for the individual. Here, if the breach of this trust by the organization, if it is made criminal, the enforcement, as I said, will be easy. And the entire conceptualization of property is made keeping in mind with the limited ability of our enforcement agencies and the judicial setup which we have. See, this privacy and data protection, if we try to conceive it more technically and more theoretically, it becomes a high-tech solution. See, hacking, as it was pointed out by Prasanna, is something which happens for who have a luxury of having a computer. But breach of privacy is something which is possible. The risk of running a breach of privacy is for all the 102 crore people who don't even know what is a computer, but they are running that risk. So when we try to bring a law, we should keep the subjects who the law is governing and where it is being enforced and with whom it is being enforced. So for that, for easier conception, this analogy is drawn, and this is not something which is an ultimate truth. Of course, this is just thrown open for debate on one end. And the real world and the cyber world, the digital world, they have their own divides. So we need to reconceptualize a lot of things in the first place to begin with. What is the real world in toto cannot be applied to the digital world. We have to re-evaluate the situations, we have to draw new conclusions, and based on that, we'll have to move on.
Thank you.
In addition to the second question, I still find that imposing criminal liability for all forms of infringement of privacy is not a good suggestion, because especially if it is the contractual relationship, if it is an infringement of contractual terms with respect to the privacy and you impose criminal liability, it's much more difficult for the victim to get compensation, because under criminal law you don't have scope for giving compensation. And then secondly, the burden is upon the state, and again it's difficult for the state to prove. So it should be proved beyond reasonable doubt, and the procedure is much more technical, much more time consuming compared to civil law. So how do you still feel that in person?
Yeah, I do agree, but when it comes to civil law, the onus of providing proof is on the person who tries to claim damage.
I think it's equal upon both the parties,
So
not just upon
now
one party.
when the entire information is vesting with one party who has himself infringed, now trying to bring an evidence beyond that is which is capable of being proved beyond reasonable doubt will become very difficult.
Yeah.